inspector to suspend the business license issued to Julie K for business premises located at 4107 West 13th Avenue. Before we begin, I would like to acknowledge that we gather on the unceded territory of the Musqueam, Squamish, and Coast Salish nations, and I have some opening remarks. This hearing is being convened by electronic means as authorized under Part 14 of the Procedure Bylaw, and as such, panel members may participate in person or by electronic means. We're all in person here today. Video of panel members speaking and vote results will be projected on the live stream and above on the screen when available. And in case of emergency where we need to evacuate the building, I will direct your attention to the exits. There are 2 exits beyond the glass doors and to the left. If these exits are obstructed, please direct your attention to the 4 exits in this chamber, which you can see here. Please use the stairs and not the elevator. I'd also like to highlight that there's a defibrillator located at the end of the hallway outside the council chambers. Clerks, may we have the roll call, please?
Yes, Councillor Boyle in the chair, Councillor Klassen, and Councillor Meisner. You have quorum, Chair Boyle.
Thank you very much. We will start with opening remarks from Robert LeBlanc, Council for the City of Vancouver. Let's just wait till your microphone's on.
Here we go. Good morning to the members of the Business License Hearing Panel. My name is Robert LeBlanc. I am Litigation Counsel with the City of Vancouver Legal Services Department. I'm just going to pause there and note that the licensee is present. I'm going to give her an opportunity just to introduce herself and perhaps the party that's accompanying her this morning.
It's Julie K, and this is my husband, Jerry K.
Thank you.
We're the owners of the property.
Thanks, Julie.
Thank you. The hearing before the panel this morning is an appeal by the licensee of the Chief License Inspector's decision to suspend the business license issued to Ms. K on December 11th, 2022 for the provision of short-term rental accommodation at the address at 4107 West 13th Avenue in the City of Vancouver. Before the panel this morning is an evidence book and a copy of that business license that was issued to Ms. K on December 11th, 2022 is located in the materials under tab 3. The suspension by the Chief License Inspector and the basis, therefore, is set out in the letter of December 21st, 2023 to the licensee, which is located at tab 12 of the materials. And I'm going to ask the panel to refer to tab 12, which is page 54 in the upper right-hand corner. And I'm going to read from paragraph 2, which is the basis for the suspension. Starting now, the city has determined that in consideration of the totality of information, including documentation provided during your audit, information received from the community, the compliance inspection, and your confirmation that you do not reside in the suite, the information does not support that the suite of 4107 West 13th Avenue is your principal residence. As per License Bylaw 4450, Section 25.1 sub 3, no person shall carry on business as a short-term rental accommodation operator unless the short-term rental accommodation being provided is the principal residence of that person. For your reference, a copy of that particular section is also included in the materials book at tab 15, page 76 in the upper right-hand corner. You'll see under the heading short-term rental accommodation, section 25.1, sub 3 reads, no person shall carry on business as a short-term rental accommodation operator unless the short-term rental accommodation being provided is the principal residence unit of that person. The letter does specify the basis for the suspension, and that basis is based on the definition that's provided for principal residence unit in the license bylaw. And I'll read that definition for the panel because it needs to be considered. Principal residence unit means the usual dwelling unit where an individual lives makes their home, and conducts their daily affairs, including without limitation, paying bills and receiving mail, and is generally the dwelling unit with the residential address used on documentation related to billing, identification, taxation, and insurance purposes, including without limitation income tax returns, medical services plan documentation, driver's licenses, personal identification, vehicle registration, and utility bill, and this is important, for the purposes of this bylaw, a person may only have one principal residence unit. The witness today is the city's chief license inspector, and I'll just note that there's a last-minute switch-up. You'll see on the order of proceedings that it was anticipated that the city's witness was going to be Mr. Koji Miyagi, the deputy chief license inspector. He's unavailable this morning, and so Ms. Hicks is standing in his place. What I expect is that Ms. Hicks will take you through the materials in the evidence book and explain the basis for her decision to suspend the license. What the panel can expect to hear is an indication that the decision required a weighing of multiple factors with respect to the claim of principal residency by the licensee against those other factors, such as the approved use of the property, the occupancy of the property, and its configuration. The chief license inspector's position is that the conclusion regarding principal residency was a reasonable one, that the suspension of the license logically flows from that, and that the decision to suspend should be upheld. Of course, the licensee has an opportunity this morning to convince this panel otherwise. Before embarking on the evidence, there are some legal and procedural matters worthy to note. First being that the chief license inspector's power to suspend the business license is set out under Section 277 of the Vancouver Charter. Under 277, the chief license inspector shall have the power at any time summarily to suspend for such period as he or she may deem, determine any license if the holder of the license has, in the opinion of the inspector, been guilty of such gross misconduct in or with respect to the licensed premises as to warrant the suspension of the license. The short-term rental of the property in the city that fails to comply with the regulations with respect to the principal residency requirement would amount to gross misconduct. This council's powers then to review a business license suspension is further set out in that section. Any person whose license has been suspended under this section may appeal to the council in accordance with the procedure for that purpose prescribed by law. And upon such appeal, the council may confirm or set aside such suspension on terms that it may think fit. Now, this panel's power to review business licenses is further set out under Section 275 of the Vancouver Charter, being that the granting or refusing of a license to an applicant, therefore, and the revocation or suspension of a license which has been granted shall be deemed to be in the discretion of council, and the council may grant, refuse, revoke, or suspend the license without stating reasons therefore, save in respect of a licensee who by reasonable efforts cannot be found. The council shall not revoke the license without giving the holder thereof an opportunity to be heard. And of course, that's the purpose of the hearing today, is to give the licensee that opportunity to be heard. And now under that section, this panel has broad powers to revoke, suspend, and uphold a business license. This is an administrative hearing. Rules of natural justice do apply, and I'd ask that the panel be mindful of the fact that the licensee is entitled to hear the allegations against them. They may respond to those allegations, they may ask questions of the witnesses, and they may make submissions on their own behalf. If you see fit then to uphold the suspension, recent law says that we should be able to discern from comments on the record what the reasons for doing so was. With that, I will proceed. We have Ms. Hicks here. I'll give her an opportunity just to introduce herself.
Good morning. I'm Sarah Hicks. I'm the Chief License Inspector for the City of Vancouver.
Thank you, Ms. Hicks. You're here today to provide us with some context on your decision to suspend the business license for short-term rental accommodation at the property at 4107 West 13th Avenue. Is that right?
Correct.
And that decision to suspend, was that a decision that was made by you?
It was.
Now, was it, as I understand it, it was made after you receiving some information provided to you by staff regarding the premises and its occupancy. Is that correct?
That is correct.
Okay. Just perhaps you can just summarize for the panel, what was the information that was shared to you by staff?
Staff provided me the information that the licensee, through complaint, the team started an audit on the license. Throughout that process, which includes an inspection and investigation into the history of the property, it became evident that the unit where the short-term rentals were occurring is an approved secondary suite, and that the licensee did not live within that suite and was not their principal residence. They lived upstairs. Therefore, they did not meet the requirements in the bylaw.
Thank you. Now, I'm going to ask you to turn to page 4 of the materials under tab 2. This has been noted as being a timeline of events. As I understand it, this is a timeline that is provided to you by staff. Is that right?
Correct.
And it outlines the extent of the city's dealings in terms of the investigation into the premises.
Correct.
Okay. I see at the top here we have a heading called approved property use. Sorry, there's a DB number and some description in terms of the history of the conversion of the building. Can you just explain what that information means?
Certainly. The DB stands for a combined development and building permit, which through a program in the early 2000s was to look at suites that were not legal secondary suites at the time and provide opportunity to phase those out, return them back to their approved use, which in this circumstance would have been a one-family dwelling. Or bring the suite to appropriate approvals and make it a permanent secondary suite. In this case, in 2006, the suite was made permanent as a secondary suite for the life of the building.
The DB number then is a development and building permit number, is that right?
It is.
Okay. And that particular permit, upon review, indicated to you that that the phase-out suite that was approved as a secondary suite through the application it was now approved as a secondary suite for the life of the building. Is that right?
That is correct.
That indicated to you that this, in effect, is a single-family home with an approved secondary suite constituting 2 separate dwelling units.
Correct.
Okay, thank you. Now, do you know who applied for that development and building permit?
The original applicant was Julie Greenow.
Okay. I'm sorry?
That is me. That was my maiden name.
Okay, thank you. Now, let's move on then in the timeline of events. You referenced the fact that a complaint was received. I see the first entry here being August 10th, 2023, regarding the reception of a complaint. Can you tell us a little bit about that and whether this is a usual thing to happen in the city, that citizens will complain about the use of short-term rental accommodation?
Yep, we received a complaint from a community member stating that they did not believe that the resident lived within the short-term rental and pointed to a description on the online listing for the short-term rental that described that the family, in fact, lived upstairs.
Okay, and that's a copy of that complaint, redacted of personal or relevant information, is contained in the materials under tab 5. Is that right?
Yes.
Okay. And I note that it was there's a quotation there in the entry under August 10th, being that I, my husband, and one other adult son live upstairs. I'm just going to turn to page 15. Oh, sorry, tab 15 of the evidence materials. Correct me if I'm wrong, but what's included in the evidence materials appears to be a copy of the Airbnb listing for this particular unit. Is that right?
Yes, it is.
And on page 73, which is the second page under tab 15, there is at the bottom of the page, in very small writing, an indication that this particular premises is hosted by the short-term rental accommodation is hosted by Julie. With that exact same information, so it was confirmed indeed by city staff that the listing did state that I, my husband, and one young adult son lived upstairs.
Correct.
Okay. Ms. Kay, I'm gonna just indicate you've got your hand up. You do have an opportunity to ask questions of Ms. Hicks afterwards. We have to follow an order of proceedings with respect to an opportunity to ask questions and make comments. Okay.
Okay, I would also like to know, when do I get to speak?
Yeah, that would have been sent to you in the order of proceedings. The city asked questions of its witness initially. The panel will then have questions to ask the witness questions, and then you will be given an opportunity. Okay. Thank you. Then moving on, indicate that as a result of the indication in the timeline is that as a result of the complaint that was received, that a case file was opened to conduct an investigation into the particular unit.
Correct.
And an audit notice was sent on August 25th, 2023, correct?
It was, yes.
And that audit notice, a copy of that is contained at tab 6. Am I right?
It is.
Okay, and if you could just explain to the panel what the purpose of the audit notice was.
Certainly, an audit notice is provided when we are looking to gather information from the licensee about their compliance with the regulations for short-term rentals. So we ask for a number of documents to confirm that they comply with the bylaw requirements of being a principal residence. Look for information including the listing, an operational summary of how they operate the property or who may operate the property for them, so that we can determine compliance with bylaw requirements.
Okay. We don't need to drill down into all of that entry under August 25th, 2023 in the timeline, but suffice to say, as a result of the audit notice that was given, dialogue was open with the licensee with respect to provision of certain information that was required, and that was furnished later on in September 2023. Is that right?
Correct.
And that includes an operational summary, the listing URL, the website, and the booking calendars. Those are contained under tab 9, just indicating the general use of the premises as short-term rental accommodation, the booking frequency. Is that fair to say?
Yes, it is.
Okay. And then a copy of the operational summary for the panel's reference is located at tab 13, page 60 in the upper right-hand corner.
Yes.
We don't need to go into that in any great detail. Further documents were provided. Further dialogue occurred with the licensee, and ultimately by October 26, 2023, it was decided that a property use inspector would be sent to the premises to conduct an inspection for the occupancy and use of the premises, right? Is that right?
Yes, to confirm the use of the property.
Okay, and why was that important?
It's important for us to understand the layout of the property, understand the confirmed use, whether or not there's been any work without permit, if the location is in compliance with the bylaw requirements, the safety requirements, and that provides an opportunity for the property use inspector to conduct the property research of what the approved use is, and understanding the approved floor plan layout.
Okay. Now at tab 4 in the materials, we have what appears to be some type of design drawing layout of a property with the notation that it is correlated to DB 411463, which is the development and building permit that you referenced earlier. These are the approved plans with respect to the approved secondary suite at the premises. Is that right?
That is correct.
Okay. And I'm looking at the right side of the page. I take it when the inspector tended to the property, he would have expected to see the property reflect what was in the approved plans with respect to the secondary suite. Is that right?
Yes.
Okay. So I'm just looking at the right side of that drawing, and the upper part of that drawing, correct me if I'm wrong, would be the entrance. Upper left would be the entrance to the secondary suite, and it enters into the kitchen area and a common area off of which looks like a couple of bedrooms, a bathroom, and a rec room are located. Is that right?
That is correct.
Okay, there's also a laundry room to the left of the entrance, to the right of the entrance in the drawing, and some access stairs to the rest of the home. Is that right?
That is correct.
Okay. Now, under the development building permit DB 411436, that schematic on the right-hand side is the approved secondary suite, which constitutes a second dwelling unit in this particular premises. All
It
right.
does.
Okay, thank you. Now, can you tell us what the inspector discovered upon his inspection of the premises? And I see the notation there being December 12th, 2023.
The inspector inspected the property with Julie, with the licensee, and found that, in fact, the secondary suite was present as per the plans on file, that Julie's nephew was living in the unit at the particular moment, but that it did match plans on hand as the approved secondary suite.
Okay, so what was decided after all of this information was shared with you?
Once all the information was shared with me, I made the decision to suspend the license because the unit is an approved secondary suite. It is its own unique dwelling unit and therefore not the principal residence of the licensee. They stated that they lived upstairs. That was all confirmed through our inspections, and therefore they were not in compliance with the bylaw.
Okay, I note just for the panel's information under tab 11. There are a number of photographs that are taken. We see a single-family home on the first page. These are the photographs that were taken by the property use inspector when he inspected the premises back in December 2023. Is that right?
They are.
And I am just going to turn to page. Page 46 on the upper right-hand side. We see a back door. That's the same back door that I indicated in the drawings, the permit drawings. That's the entrance to the secondary suite. Is that right?
Yes, I see that on my page 47.
Oh, okay. I'm not sure why they.
It is the underground. The photo that I am looking at is the door to the unit, which appears to be underneath the deck for the upper unit.
Okay, and the photographs that follow that in the evidence book show the kitchen of the unit, show the rec room living space as well as the 2 bedrooms. Is that right?
The photos that follow show the bedrooms for the unit, the rec room with the table, and the kitchen.
And the
the rec room and then the kitchen with the table in it.
And the earlier photographs indicate the dwelling unit upstairs, and I'm looking at the second photograph in the package. This would be the upstairs kitchen.
Yes.
So again, the photographs indicate 2 separate dwelling units in the home.
They do.
Okay. Now I'll just draw your attention then to the definition of principal residence unit that I read to the panel at the outset of these proceedings, and that would be the very last point under that definition, that a person may only have one principal residence unit. The license for the provision of the short-term rental accommodations at this particular secondary suite was held by the licensee. It was then your position that the licensee could not occupy both the secondary suite as a separate dwelling unit as well as the upper floors of the residence at the property simultaneously.
That is correct.
Okay. And it was on that basis that the suspension was issued.
It was.
Okay, thank you. Do you have anything that you'd like to add?
No, the property, is an older property. Through the suite conversion, there are stairs that you can see in those plans that do connect the upper and the lower unit. That is not abnormal, particularly for older homes, to have an interconnection within the units. It is still approved as a fully separate dwelling unit for the purposes of habitation. and therefore would require two separate principal residents.
Thank you. Those are my questions for Ms. Hicks.
Thank you very much, Mr. LeBlanc and Ms. Hicks. Panel members, do you have any questions for the witness? A reminder that this is the only opportunity to ask questions from the City of Vancouver witness. Councillor Meisner.
Yeah, thanks very much, Chair. I'm just hoping to hear from the witness about, I mean, from the evidence I've heard today, it seems quite clear that there are two separate dwelling units in this particular home. So I'm just curious to hear your perspective as to why you believe that you're not in violation.
Sorry, are you asking me?
Yes.
So, this is the time to ask questions of
Oh,
the
I
City of
apologize.
Vancouver witness, Sarah Hicks, and we'll get a chance for
Okay,
those questions.
so there's a preview.
Yes, we'll get
Yeah.
to it. Don't
Sorry
worry.
about that.
Yeah, we'll make sure that there's
Apologies.
time for that conversation.
First hearing.
No problem. Any questions of Sarah Hicks?
No. Thank you.
Thank you, Councillor Meisner. I am going to advance myself. I don't think I have to pass the chair on. Ask questions here. I'm curious to understand. I appreciated the clarity that this is a legally separate suite. Is there a process in the City of Vancouver where single-family homes with secondary suites like this sort of reattach those suites to the main property and turn it all into one unit? And what is that process? And does it happen often? And would it work in this situation, or what would the limits be?
Certainly, to revert a suite, to remove that secondary suite from a unit, there is a permitting process to occur. They could apply certainly for that if they'd like to. Through that evaluation process, they would be notified what would be required, like removal of the kitchen would certainly be first and foremost of that. And if there are any other code-related issues that they would have to meet for the day. Reverting it back to a secondary suite, if it were to be removed, would be more complicated because as building codes change and upgrade, additional requirements may be needed to return it back to a secondary suite.
Okay, that makes sense. And can you remind me if family members or others are using the secondary suite when they visit or are home from school, what are the time, are there time requirements in which it needs to be occupied by a longer term renter, or what's the balance there?
So the unit must first and foremost be that person's home. It has to be where they live the majority of the time. We would consider an application that came forward and look at the merits of that particular circumstance in and of itself. The bylaw itself does not set out those time requirements because they really are circumstantial. We do not require the unit to be long-term rented. However, the unit cannot be short-term rented unless it is by the resident of that particular unit.
So in a situation like, and I don't know that this is the current situation, and I'm looking forward to hearing more, but just reading the documentation, if an adult-aged child were away at school for 8 months of the year, but were living there as their primary residence when they weren't at school, but presumably have a primary residence, whether it's a dorm or elsewhere, how do we determine? Can that individual have two primary residences? I guess that's why I'm asking about the time requirement.
An individual cannot have two primary residents. There can be certainly a tenant in that suite, and they can look to short-term rent the suite. They can seek a license if they are the tenant and the residents in that particular unit. And again, each circumstance would be looked at on its own to determine if that person met the principal residency. So we would look at circumstances of where else they live and to understand their particular unique circumstances.
Okay, I appreciate that. Those are all of my questions, and Councillor Klassen, I'll advance you.
Thank you, Chair, and I'm going to build upon some of the questions from Councillor Boyle. I just you mentioned that there was no time requirement, but we do make a distinction between long and short-term rentals. There is, I guess, evidence here that a nephew lived in the suite for at some point. I don't know if it was on a iterative basis, like coming back and forth from school. But what are the allowances then if somebody was there for when they're not at school and back living in the city? What about the time outside of those additional months where the person was at abroad at going to school? Is the place allowed to be? Would it be considered the principal residence of that student, and then the actual times when they were away being let out in a compliant way with the short-term rentals?
There's the potential for that, certainly. We would look at the circumstances of that individual, understanding where are all of their documents to show that where they are the principal resident. We would look at their leases, their taxation, all of those kinds of items to understand where do they live, where is that purpose of the primary resident.
And those things were looked at in terms of the available documentation supplied by the owner of the property?
So the owner of the property is the licensee and they reside upstairs. They cannot hold a license in another unit that they are not a principal resident of. So they cannot hold a license for the secondary suite in the basement. The tenant could potentially hold that if they are able to show us documentation that they are the principal resident of the unit, but not the homeowner.
Okay. If you bear with me, I am trying to understand, better understand the policy as it stands. So, so I understand now. You're saying that the fact that the unit is a part of their home, but for it to be let out in any other way, it would have to be the actual renter that would have the business license?
Correct.
Very interesting. Okay. And obviously, this came to our attention due to a complaint from possibly somebody who was at least aware of it, living in the neighborhood or whatever. Is that and the listing that you were able to sort of pull up there is there more evidence than that report and that one listing? There's a lot of paper here and I've been going through it, but I'm trying to ascertain what kind of information you've brought forward here in terms to making the case.
Certainly. So the complaint started the audit process, which started the communication with the licensee in order to gather the documents, understand the property layout. Through the conversations with the licensee and through the inspection, it was determined that they did agree that they lived upstairs. Through the property use inspection and historical look into the city's files, we did determine that the unit that the licensee was putting up for short-term rentals and had the license for was in fact an approved secondary suite, which is a separate dwelling unit. And therefore, knowing that the resident lived upstairs and not in the unit itself, they're determined not to be in compliance with the bylaw.
And I guess this hangs on that the earlier question of who's actually got the license to do it, whether it's the actual tenant down there or the owner of the, I guess, separate living area upstairs. Okay.
Correct. And a similar circumstance would be for a laneway home as well. If the property owner or renter lives in the main home, they cannot short-term rent the laneway home because they are not the resident of the laneway home.
I'm running out of time. I guess I only have 5 minutes to ask the question.
I wasn't going to pay close attention to it. If you-
Okay. Okay. Is it quite common for somebody to rent a unit and then get a business license so they can sublet it? Is because it seems to me if I'm the homeowner and somebody is effectively profiting from my separate unit, laneway house or basement suite, I'd have some questions about that.
So the bylaw does require that you have landlord approval or strata approval if you're in a stratified property. So through that process, if as a landlord you don't want a tenant participating in the short-term rental market, that is certainly your call as the landlord.
Okay.
If we see that you do not have landlord approval or strata approval, a similar process would occur because you're no longer compliant with the bylaw.
And in your experience of seeing these cases, is there ever an agreement between the renter and the primary property owner to say that I'll get some of the revenue that you're generating through this process, or is that fall outside the lines of the bylaw?
We don't see those kinds of documentation. We do see leases for properties to confirm the rental contract for that particular individual. It's rare, if ever, that we would hear about any financial recuperation for that type of relationship.
Okay. All right. Thanks, Sharon.
Thanks, Councillor Klassen. So, Julie, next in the order of proceedings is a chance for you to ask any questions of Sarah, of the city witness, and then just so you know, just after that is your opportunity for opening remarks.
Do I have a mic?
Yeah, that one's right in front of you.
Okay.
You just pull it down a little closer and speak into it.
Great, thank you.
I had two questions, please. One is, it sounds like a lot of weight is being put on the fact that in my public listing on Airbnb, I was at pains to point out to anyone who might wish to stay with me that I and my family are present upstairs. I used the word lived upstairs, but is it not possible that I was only trying to say, we will be in the house, don't plan on having a party?
I couldn't comment on your intentions for the advertisement. The information is all part of evidence gathering for us, so it helps to understand the circumstances.
Okay, I just would not like the whole decision to hinge on my use of the word live upstairs, because I did not realize how politically sensitive that was, and I was not meaning to imply that the basement's not part of my house. My second question is that from what I could see of the redacted complaint letter that you received in the summer, the renter's concern was about bylaw enforcement and whether it was fair. It was not a grievance about any inconvenience to them from my short-term rental. Is that accurate?
It is a complaint that there may be a contravention of the bylaw. They don't speak about grievances.
Okay. I would like to go to the slides I prepared now, if that's all right.
Yep, that is all right. So we'll move to opening remarks from the licensee. Do you mind if I call you Julie rather than the licensee throughout? Okay.
Julie's good.
Julie's good. Just checking. Thanks, Julie. We have slides that we will see on the big screen here in just a moment.
Okay. That's our house. We've owned it since 1998. It had a long pre-existing basement kitchen with a stove, which I think the city would have records of on our first renovation permits. And we did do all the renovations under permit. We're appealing because we believed while we were operating a short-term rental that we were doing so within the bylaw, and that if we were not, then it's perhaps the bylaw that should be reviewed. There are three parts to what I want to tell you today. The first will be the history of our home use, and looking at the question of who's deemed to occupy the basement. The second will be to point out some of the public benefits of part-time home sharing, which I think the bylaw overlooks. And the third, my penultimate slide before the conclusion, is to point out some ways that various levels of government could encourage more full-time rentals in owner-occupied houses. They're really leaving a lot of options on the table right now. Slide 2, please. So these are ways that we are currently using our basement. You'll see that we've got it fully furnished for our own purposes. I won't spend a lot of time on that because I think the first part of this meeting might have gone already longer than you hoped. My favorite room down there is that media room. It's the only place in my house where more than a couple people can watch TV. And the second would be that kitchen, because I have only one fridge upstairs and I don't have opportunity to prepare camp food and to use my food dryer. That's my food dryer in the back left corner there, because I prepare my own camp food. Anyway, one of my friends who is a lawyer and who has attended a movie night in that media room and has attended a mom's dinner in that dining room, which we like to do downstairs so we can gossip about our kids without the kids hearing. She says that we use our basement more than anyone else she knows and that she would be willing to testify to that. Anyway, slide 3, please. For a long time, we lived without the luxury of those extra spaces downstairs. When we first bought the house and found ourselves with a big mortgage, and later when we had little kids, we wanted the full-time rental income more than we needed to make personal use of the space in our basement. We renovated, really as soon as we moved in, we renovated the derelict existing suite. There are police records about that suite. The neighbors were relieved when we renovated that suite and got it approved. And we rented our basement unfurnished full-time for 19 years. So it's not like we have not done our share to provide full-time accommodation. We always assumed, though, that at some point we would have the whole house to ourselves with no tenants. Now that our kids are older, that's them again in the second picture, we wanted a place they could have friends over. Our needs for space were evolving, and we were mortgage-free. Slide 4. We always aspired to be a good landlord, a good host, and a good neighbor. Whether we were doing short or long-term rentals, I always gave the occupants parking instructions. Those two pictures show on the left the front street in front of our house. That's my van parked in front of our house. And the side street, which is one lot away from us. We're one lot from the corner. I always instruct my occupants to park on that side street so that when owners come home, they have parking in front of their houses. And I further specify that in any case, they should not park in front of my elderly neighbor on the west side because I want him to have a space right in front. Even when one side of 13th Avenue is blocked off for street cleaning, there's always enough parking on that side street. I always, for both my tenants and my short-term rental guests, make them agree to quiet hours between 11 p.m. and 6 a.m. And as you can see in the example of my Airbnb listing, I did the same thing when I was putting using the UBC Rents line to advertise the suite full time. I use keywords like calm. That's the first word of the title of my listing, and quiet and residential. And I note that we will be present in the house. I don't believe our short-term rental has ever inconvenienced any of our neighbors. And in fact, the woman who lives on that, the daughter of the older man who lives in the house on the west, appeared not to even realize we had a secondary suite until I was talking to her a month or so ago. To realize we were doing short-term rentals. And the same for the woman across the road from us on the other side of 13th. I think, in fact, the guests who know they're going to be subject to review on Airbnb are inclined to be quieter than student tenants might be. Anyway, to our shock and surprise, our practice of sharing our basement part-time as a duly licensed short-term rental has earned us this suspension letter. The first I heard of it was a letter from the city on December 21st, which I experienced as really cruel. This letter gives me 10 days to do something and says I should address my questions to Michelle. And guess what? When they sent that letter on December 21st, they knew full well that Michelle was going to be going on Christmas holidays, that no one would be here until January 2nd, that no one was going to return my calls or answer my questions. So in the end, I had to file for appeal in the absence of information. Slide 5, please. This is our understanding of our situation. we're prepared, what we say is we're prepared to share our basement part-time, but not full-time permanently for the years the tenant might choose to stay. We used to share it full-time. Right now, we want to have some use of it ourselves. What we hear from the city is you must share it full-time or not share it at all. Next slide. Why? What we hear is because it is a self-contained housekeeping unit. You cannot be the principal residence of it. Next slide. How can our own basement not be part of our principal residence? It's a part of our own house and we use it as such because it has a stove in it. To occupy that space, you must rip out the stove and all of the connections for it. Next slide. How would that help anyone? The stove's presence does not hurt anyone and we use it. And if we have to rip it out, that would hurt future renters because it prevents us ever doing full-time rentals again. Next slide. This is from the city's website from the FAQ on secondary suites. I can't quite read that from here. Let me find my own version. I just wanted to read out the yellow highlighting for you. But it confirms that to remove a suite, what's required is to take the stove out. Yeah, I would like to remove a suite. You have to remove the range and associated wiring up to the supply circuit breaker. Next slide, please. This is another page from the city's website. It's the regulations for secondary suites about short-term rentals in Vancouver. What is allowed for short-term rental? A short-term rental can only be operated from your principal residence, the home where you live as an owner or tenant, and used for billing, identification, taxes, and insurance. So we ask ourselves, does our basement have a separate mailing address? No, it does not. Does our basement have a separate tax address? No, it does not. Do we need a separate home insurance policy for our basement? No, we do not. Does our government ID distinguish what part of the house we live in? No. And I put the next question in italics because it's not part of the city's definition. But can our basement be strata titled? No. And I would suggest that might be a good way to distinguish what could be a secondary suite and what cannot. If it can be sold off separately, then indeed it's a separate unit and one person can't occupy two of them. Anyway, so we were looking at that, and can we conclude that our basement is part of our principal residence? Well, we sure thought so. Next slide, please. And this one's for our lawyer. This was a concept Jerry remembered from his business law education, and I confirmed it with a friend of mine who's a lawyer, and I got you this quote off a local legal services company on the website. Contra proferentum means that where a term is ambiguous, the preferred meaning should be the one that works against the interests of the party who provided the wording. In other words, it's not really our fault that we understood as owners that we could decide whether our basement was available to be a full-time secondary suite rental or whether it was not, because we're using it. And as far as we're concerned, we do occupy that space. Next slide, please. So I understand, I'm sympathetic to the city wanting more people to provide full-time rentals and not just do short-term ones. And this graph is how I imagine the public benefit of part-time home sharing would work for people who are or wish to be full-time residents. When the home's only being shared part of the time, the value to those people is very low, and then it would increase steeply until they only get full value when it's shared 100% of the time. However, that's only one group of people that might like to use a space. Next slide, please. This would consider the benefit of part-time home sharing for undergraduate students, where they would get maximum benefit much sooner when they're only in town for 8 months of the year, about 2/3 of the year. They achieve maximum benefit then, and if they have to pay for the place longer than that, it's maybe not as bad as being homeless, but they're wasting money, and the net benefit for them falls off. Next slide. This one shows the benefit, the public benefit for Vancouver visitors of doing short-term rentals. The more time that a space is shared for short-term rentals, the more people benefit from it. And I do want to say that to me, it felt like I was offering a public service when I'm running a short-term rental. Our visitors are academics or people visiting family at UBC. I had a professor from Beijing, math professor, stay for 2 months with his wife because he wanted to bring his wife. Apparently, UBC does not provide these people with enough accommodation. I don't think there are even any hotels west of Granville. About 1 out of 10 of my visitors are actually hospital patients from the interior who they or their children are sent down here for medical treatment. People stay with me because they're visiting family in the neighborhood. So there is a lot of public benefit from letting there be some short-term rentals. And when we determine, as we are right now, that we're not prepared to share our basement full-time, and the city then prevents us from sharing it at all, a lot of public benefits get lost in that process. Now, next slide, please. Yep. This one shows the government benefit, which is another public benefit, of the income that comes from fees, accommodation taxes, and the tax on rental income. Short-term rentals, I don't know why there are 2 lines on there, but the point is short-term rentals provide a lot of public income. And the reason that that line near zero starts so high is because this year, if as soon as you do a single night of short-term rental, you pay the city $1,000. Although I'm just drawing these for illustration purposes, I do think that the ratio shown there between the fees from tax on long-term rental income and short-term rental income might be approximately accurate. Next slide, please. Because this is the owner's benefits from short versus long-term rentals in terms of their income. And I recognize that this is a challenge for government in promoting more long-term rentals. I have been operating at about that intersection point on the middle of the line where I'm sharing my home half or maybe less than half of the time, and I'm getting about the same income I would from doing long-term rentals. Anyone who wants to share their home more of the time could make more money doing short-term rentals. And of course, that's the incentive that's led them to spread in the city and led to the challenge the city is trying to address with this bylaw. But I do want to point out that you can see in the documentation that I provided the city, I am not maximizing my income, and I am putting short-term rentals in there less than half the time. Okay, on the next slide. Oh, I lost all the color highlighting. The next slide is about what's the difference for an owner? What are the benefits and costs of doing a short-term versus a long-term rental? The maximum income is higher doing a short-term rental. How could various levels of governments close that gap if they want to promote more long-term rentals? Potentially, they could lower the tax rate for income that's derived from long-term rental in part of your own house. And it might be worth noting that once someone no longer has a mortgage to pay, it becomes much less worthwhile to share their home at all because they can't deduct interest cost anymore from the income they're paying tax on. The labor required, this is the main and for me huge disadvantage of short-term rentals. You have to do a lot of cleaning and it's really tedious. Doing long-term rentals, you need to put very little labor in. The landlord's ability to use the space intermittently is very high and flexible under short-term, and it's non-existent under long-term, potentially for many years. I don't think governments can do very much about that. The risk of occupants breaking house rules is, in my experience, very low under short-term rentals. Everyone's government ID is verified and everyone knows they're going to be subject to review. And it's substantial under long-term rentals. And I'm afraid that it's gotten even higher since the eviction freeze on the pandemic. Tenants seem to have a different attitude. Assistance when you have problem occupants. Oh, sorry, I was going to suggest that one thing that could be done to address that concern for potential landlords is to maintain a registry of bad tenants so that tenants do know there is going to be some consequence for breaking their promises. For example, my fear is if I take a long-term tenant, they might sign an agreement that they won't smoke on my property and they'll have quiet hours between 11 and 6. They might move in and say, I don't care because I know it takes you 1.5 years to get me out of here. Which comes to the next section, assistance with problem occupants. On Airbnb, it's promised I never had to use it. For long-term rentals, it is much too slow. And I know this not just from media reports that you've probably all seen, but also from problems a friend of mine had last winter. So an obvious thing governments could do to reduce that gap is to provide immediate assistance if the landlord is having problems with a tenant sharing the house in which they themselves live. The risk of non-payment under short-term rentals is very low because Airbnb collects it in advance, and it's substantial under long-term rentals. I don't know why governments can't say that they'll repay the landlord and then collect the tenant's debt themselves, because they have far more resources and means to achieve that than the tenant does. Control over the length of occupancy is very high under short-term rentals and very low under long-term rentals. I was concerned to find out recently that even if I give my nephew a fixed-term lease of 8 months in my suite, if he decides he wants to stay longer, I have no legal means to have him move except by wanting it myself for more than 6 months. When my children come home in the summer, they're only there for 4 months. I see no insurmountable obstacle to letting landlords have enforceable fixed-term leases. I think the concern might be that people would use it to get around rent controls, but you can obviously get around that. And the final category is external insurance coverage. Airbnb provides an additional $1 million of insurance if anything goes wrong with a guest staying in your place. The government currently provides $0 if anything goes wrong with a long-term rental. Public insurance could be offered for a fee, and to encourage people to rent to hard-to-house tenants, governments could provide no-fee insurance. Anyway, that's all a bit of an aside because I think it does deserve more consideration. I've written similar things before to both Ravi Kalan and David Eby, who is my MLA. Okay, slide 16, please. The last slide, I guess it is. Conclusions. We believe that we are operating our basement as a short-term rental in compliance with Vancouver's bylaw because we determined it was no longer available to be a secondary suite. We believe it's our right as homeowners to determine whether any part of our house is or is not available for full-time rental. We believe that by sharing our basement part-time rather than not at all, we are providing significant public benefits as well as government revenues. And we believe that requiring us to tear out the basement stove would cause public harm, not benefit. Are there any questions? Oh, yes. Would you like to add anything?
I am Julie's husband, and she's in charge, but there's a couple of points that I want to raise in addition to what she made. It seems as though the city is looking at this as a binary. You either occupy your basement or not, or you occupy your house or not. What the bylaws don't contemplate, and what the reality of the situation is we occupy the basement a lot. We have boys who are right now away at university. When they come home, we need the space. They have friends over in the basement. We have relatives come over at Christmas time for cross-country skiing and family things. They often stay for a week, and we do lots of things together. They're in the basement. We use the basement for preparing camping food. We use the basement when it's not in short-term rental. We use the basement a lot. The city putting this in a binary category, because you occupy the upstairs, you can't occupy the basement, is just wrong. That's not our usage pattern. There's nothing in the bylaw that specifies you must use the basement yourself for a week or a month or 4 months or whatever the timeline is. The reality is we use it, the whole house, for a significant portion of the year. And when it's available for rental, we want to get some extra money if we can, but we use it. This is the totality of the house is our primary residence. We use it all for months at a time, every year. And as just to amplify something Julie said, if we were to lend our basement suite out on a leased basis while our kids are away at university, and when our kids come back in the summer, we'd want use of that space. There's no way of removing someone who wants to overstay the lease. They're allowed under current provincial laws to stay forever. There's no way to enforce a fixed term lease. So we see, based on our occupancy pattern for decades, well, when the kids were young, we didn't use it, but for quite a number of years now, our boys are in their 20s now and at university. Based on the actual pattern of usage, this is all a primary residence, and it should be allowed because the alternatives to us as landlords are worse.
Thank you for all of that. The order of proceedings has an option for you to call witnesses. I just want to check that you don't have further witnesses.
We did not bring a witness.
Okay. I just want to make sure I'm not skipping that. So, council, a chance. Let me make sure I'm getting the order right. Panel members, do you have any questions for the licensee? And a reminder, this is your only chance to ask questions. I'll advance you first, Councillor Klassen.
Thank you, Chair. So, thanks for the presentation and interesting. I mean, you were on the one hand making the case that this is a part of your home and you're occupying it and using some of the rooms down there, and then you had a further kind of case that you were trying to make that was separate. That was interesting to me. I just wanted to say it was interesting. Although I don't know whether we're here to kind of judge the policy per se. We're really here to talk about the compliance. I do find the photos themselves to be quite telling. The fridge is full of extra overflowing food that you probably don't have. The reason I know that is because we have a similar situation with a basement with a separate fridge, and we put extra, containers of milk and other goods that we need to have there. I look at the bathroom; it's got a water pick in it. A water pick is not something you would necessarily leave out for a short-term renter. It's a very it's an item because for sanitary reasons you would not be widely sharing. It would probably be something that so it's a spare bathroom that is being used. I mean, the impression I get is that it's being used. I look at the contents of the freezer, stuff that's leftovers and other things that you spare freezer space. Again, I kind of relate to that experience. I do, and the fact that it has a separate entrance. Well, I mean, all homes of this
Councillor
kind.
Klassen, I'm just going to remind you this is a question time and there's statement times later.
Thank you. So I guess can I just better understand the configuration of your home as to I'm sure it's just a doorway and a stairway that goes down there, but the connection back and forth and the laundry that's there, is that the only laundry in the house that you have?
It is the only laundry in the house, and our stairs come down from the kitchen into that laundry room, with the door being into the basement kitchen right there. And I do prefer not to share that laundry room with short-term renters, although I will when they're staying longer.
Okay. And just the desk here with the computer opened up and things like that is how's that room being used by somebody who's using it on a short-term basis, or are any of these rooms, aside from some of the kitchen activity you described, are there other rooms that you would use more frequently? You mentioned the TV room, right?
Yes, I didn't dwell on that because I was afraid we had a time constraint. But that desk would be where my husband finds a quiet place for writing for the BC Marine Trail website, which he's provided, I think, most of the content for. And the computer on it at the moment is my nephew's because he didn't get accommodation at UBC.
Okay. Right. Okay. I think those are my questions. Thank you.
Thanks, Councillor Klassen. Councillor Meisner, you're up next.
Yeah, thanks very much. And thanks for the testimony. It is very detailed and appreciated. One question that stands out to me is, or a discrepancy, it seems to me, and maybe you can help explain it, is you mentioned that you don't want to rent your basement out all the time. You have a son, I believe, two sons that use it. But I noted in the evidence package here, the calendar document goes from September 2022 all the way to August of 2023. And it appears you're offering it for rent every single night. So I'm just curious why you haven't blocked off specific weeks, for example, for your sons to use it. I didn't see any blocks here. I just see bookings.
Yeah, I think all you can see on there are the bookings that I did get, because that was the information that was asked for. I do block off periods when I know we want it. For example, I block off the week at Christmas because I want that kitchen to help prepare family meals. I want space where my kids can have their friends over in private. During the other months, I think even in the busiest summer months, I doubt that there's even one where more than 50% of the nights are rented. And I control that with the booking sightings. I require a 4-night minimum stay and I require 2 days free between bookings. And so it often works out, of course, that those are not optimized. There might be gaps of 3 days apart from the 2-day buffers. I don't allow them to put shorter bookings in those spaces. So when my family wants to use the basement, they can plan around the bookings that we get.
Okay.
Oh, and I don't allow late bookings either.
To use a specific example, our oldest son has a girlfriend, and for some reason they like to use the basement bedroom that has a queen size bed when he has only a single bed in his bedroom and his
I think I
girlfriend
know
only
why.
has a single. I can't understand why, but they reserve with us ahead of time. This is a week where we can be together. Can you block it off? And we do. But there's this whole iterative process, managing around bookings, managing around when my son wants to use it, when they can get friends together for parties.
Yeah.
It all goes into the mix.
Yeah. I just noted in December 2022, I didn't see any time blocked off. I see a booking from the December 7th to the 23rd, and then I see from December 24th to the end of the month, it's up for rent. Is that not correct?
I don't think that on those are screenshots I got from asking the Airbnb to bring up my past calendar. I don't think that they're distinguishing times I blocked off in advance from times that just were not booked.
Okay. Yeah, I'm not sure because it's just a printout and it's not a dynamic, like I don't have the website in front of me, so.
Yeah, I don't think what I had in front of me was dynamic either.
Okay.
It was like a record.
Okay. Okay, thanks for that. Just because I don't have a ton of time, I'm going to move on to the next question. The stove, is it a gas stove or electric stove down there?
It is a gas stove down there. It always was.
So it'd be more complex to take that out, obviously, if a gas line, et cetera, than an electric stove. You could just unplug it.
Yeah. Okay.
Okay. And let's see here. I'm just curious. You kind of referenced it in the presentation. How does the income from running this as a short-term rental compare to what you would get for renting it out full time? Do you know what the market value of that basement would be on the rental market if you were to rent it out full time?
I have an approximate idea, and I think that the amount I'm sharing at short term is giving me the same income I would get renting it full time, but
And
with
what
a
would
lot
be the
more
full-
work required, which is a huge
Yeah,
downside.
lots of cleaning and stuff, I understand.
Yeah.
Yeah, so what is that estimate for full-time rental? If you were to rent it out full-time, what would you get per month?
Because it's furnished, it's in a different category than it used to be. I expect I can get at least 2,500 or 2,600,
Okay.
but that I might have more challenges with tenants turning over. Our tenants in the unfurnished place would stay 3 or 4 years each. Whereas the furnished place, because it's at a higher price, is not the same bargain for graduate students that the unfurnished was.
Yeah, it'd probably turn over each year, I would imagine.
Yeah, or if not more. I would have people who wanted to stay for a couple months, not forever.
Okay, that's time for me, so thank you for answering those questions. Appreciate it.
Thank you, Councillor Meisner. And my questions were asked by my colleagues, so I don't have any further questions either. Let me just run us through the next few items in the order of procedure. So next, Mr. LeBlanc, if you have questions for the licensee or
I
witness.
don't have any questions for the licensee.
Okay. Then we'll hear closing submissions from the City of Vancouver's council. The licensee, Julie, you'll have a chance to provide closing statements, and then we'll move to some discussion.
Thank you. Just from the top, I want to be clear that this hearing is not about whether Ms. Kay is a conscientious homeowner or a conscientious Airbnb operator. By all accounts, she appears to be so, but that's not a question for the panel. It's also not a matter of whether or not the downstairs has a stove in it, or whether it's used to host guests or have dinner parties. It's also not about what Ms. Kay thinks the law should be. It's also not about ambiguities, and I'll point specifically to that adoption of the definition of principal residence unit that defines it in the sense that a person may only have one principal residence unit. That's very important for this panel to consider. The ultimate question is, what is at the property and what is the approved use of the property? The development and building permit that was issued and applied for by Ms. Kay indicates that it is for 2 dwelling units. There is an upstairs living unit, there is a downstairs living unit. The licensing provisions for short-term rental accommodation were adopted by Council specifically in response to the housing crisis, and more specifically, to deal with the contribution that short-term rentals play to that housing crisis. The bylaw is crafted in a way to ensure that where a separate dwelling unit exists, that it is first and foremost used as somebody's principal residence. Because when parties have an opportunity to use that residence exclusively for short-term rental purposes, it will deplete the city's permanent housing stock and further exacerbate the housing crisis that we find ourselves in. I understand what the licensee is saying. We have a unique building here where we've got an interconnected basement unit. They want to use it. They've chosen not to rent it out full-time, and that's certainly within their purview to do that. But in doing so, that doesn't make the downstairs unit, the separate unit approved under city plans, to be part of their one dwelling unit, which is upstairs. It still remains a separate dwelling unit. And so long as it remains a separate dwelling unit, the provisions of the short-term rental license bylaw will apply. And they will apply because if homeowners are allowed to use separate dwelling units that they own for short-term rental purposes for their own benefit, we will very quickly find ourselves in a situation where homeowners will avail themselves of that opportunity every chance they get. We know that. So I have some sympathy for the fact that the homeowners here have not chosen to rent out their suite on a full-time basis. Certainly the city, through its policies and through the license bylaw, would like them to do that to alleviate some of this crisis that we find ourselves in, but it is certainly well within their rights not to do so. But because it is a separate dwelling unit, they cannot then avail themselves of that unit to provide short-term rental accommodation and further impact the housing challenges that we find. That is essentially how this panel needs to take a look at this particular case. We've heard from Ms. Hicks that there are ways for this downstairs unit to be used for short-term rental accommodations, but Ms. Kay cannot be the license holder because she lives upstairs. If she rents it out on a full-time basis, and the person who then occupies that unit decides to take out a license and avail themselves of the provisions of the short-term rental accommodation bylaw, then they can do that. Similarly, the licensee in this case can use their upstairs dwelling as a short-term rental accommodation if they wish to do so, because they live upstairs. They're the permanent resident upstairs. But what they can't do is hold a license for a separate dwelling unit that they don't occupy as their principal residence. To authorize that would open the door to a lot of abuse to the system. And I think we'd quickly find ourselves back where we were before the city instituted these policies and these
Thank
Those are my
you.
submissions.
Thank you, Mr. LeBlanc. Julie, do you have closing comments?
I did. Sorry. Do you want to go first?
You can go first.
No, I want to.
Okay. So council's legal representative is arguing that these are two separate dwellings and we can only occupy one. The actual pattern of usage is that we occupy all of it some of the time, a significant portion of the time. And we think it should be up to us to determine, and it's certainly consistent with the historical pattern of usage, it should be up to us to determine the boundaries of that principal residence. Some of the time it's available for rental. Some of the time we need it for our own use. And we think it should be us that's making that decision, not the city arbitrarily saying, no, 2 units, you only occupy 1, when that's clearly not the situation. And also there can be their whole definition of a secondary principal residence for the basement, as my wife said, it can't be a secondary principal residence for someone else because it's the same address as us. So the city's bylaws, in this case, I think are quite ambiguous, and that ambiguity, particularly with respect to our usage, needs to be, for our benefit, not the city's benefit.
Okay, I did want to add a couple things. I think I'm disagreeing with council about what's making it a separate dwelling unit. As far as I can tell from the city's bylaws online, it is the fact that there is a stove in it and that I once had it approved as a separate dwelling unit. If I didn't want it to be a secondary suite, I would have to take that stove out. But that, to make me do that would seem counterproductive. It's just spite because the stove's not hurting anyone by being there. And it makes it less likely that I'm going to, in another year or two, want to rent it full time because now there's a big barrier to getting the stove put back in. The bylaw actually says you have to rip the connections out to the wall, like not just to the stove wall, but to where they enter the house. I also want to reiterate that we believe sharing our home part-time is creating more public good than if we didn't share it at all. And so again, preventing us from sharing it part-time would be counterproductive. I understand, I sympathize with the city wanting there to be more full-time rentals, but I believe they should look at other definitions of what can be a short-term rental. For example, things that can be separately strata titled shouldn't be short-term rentals. And I believe all levels of government should be looking more at carrots to encourage long-term rentals and instead of just sticks of prohibiting short-term ones. And that's what this slide I showed you was all about. Short-term rentals are offering multiple disadvantages compared to long-term right now. And part of it is because it's so scary to let a tenant move full-time into your home. There's way too little support for when there are problems. So even when our desire to use the space ourselves changes or evolves over time again, there will still be the barrier that we're afraid to have full-time tenants anymore because of the horror stories we're hearing.
Is that all for your
I think so.
statements?
I think I've tried to incorporate the concern about needing there to be full-time rentals in the city. I've provided those for 19 years. My needs right now are different, and we believed we were operating within the bylaw because we feel it's all our house and we do live there.
Okay. Thank you. Panel, we're moving into discussion and moving a motion. And Councillor Meisner, you are up. Okay. Councillor Klassen, then you are up.
Okay, I'll move the motion to begin discussion and debate.
Just to clarify, we don't need a motion to begin discussion and debate. We need a motion
For voting purposes?
For voting purposes, so we can discuss, and then we will need a motion either to uphold the staff recommendation that the business license be suspended or to reissue the business license, in which case an appropriate reason needs to be included in the motion.
Okay.
And if you, we can, I think, get the clerks to share that language by email, if that would be helpful to have in front of councillors. Is that we rotate business license hearings, so we're not always, we don't have as much practice on this piece as some other items. Clerks, can you share by email the language options? Okay. And look for those. Any comments while that is being circulated?
Sure. Okay.
Discussion?
Noting my clock here, but I'll begin with just underlying what is clear. We're here talking about the application of the bylaw. It's not a question of the fairness or whether the bylaw needs to be amended, and that's for another discussion. And I also will emphatically acknowledge that there is heightened anxiety that relates to in the city to the concerns around the availability of housing, long and complex conversations around the whole nature of short-term rentals and what have you. All of those things are very present in the background and need to be understood. But I am not convinced that the future of our STR bylaw hangs in the balance with this one. I have listened and looked at the evidence as put forward here in the package, and find that there is some real lack of clarity for me as to the use of the home. Now, I understand the DB, the development and building permit that was provided. From what I heard early 2000s. So this is essentially probably an actual work that happened 20 years ago when this family had young children and had only bought the home in the late 90s and were working to pay off their mortgage. So it made sense that they would have rented out the basement. And I did the same thing. I am one of the lucky people in this city, and I always acknowledge that every time is that I own a home, a detached home, my wife and I, and we have a basement that at one time was rented out. It was a mortgage helper. It is now space that we use generally to ourselves in a similar way. The evidence presented a number of photos of the suite, and it's a very lived-in looking place. It mentioned having adult children coming home from school. It mentions the fact that there might be times when that space might be more appropriate for visits with friends. And I also look at what's in the fridge. This is what's been presented to me. I look what's in the bathroom, and I see leftovers and extra space for foodstuffs that wouldn't fit upstairs in the fridge. It's an older home, so there's not a lot of room for the extra space for kitchens and I can relate to, although we don't have a stove anymore in ours, we got rid of it because we never used it, with the idea that you might need to use it for preparing meals during vacation time, during the holidays. The fact that the laundry is separate and used by the home, the area, the suite itself, I realize that it's downstairs and there's a door that closes it off, but
Councillor Klassen, I'm just going to gently draw your attention to your time. I'm not going to be strict about it, but language has been circulated by email.
True, but you did start me at 133. So I'm,
Oh, I didn't notice that.
Yeah, okay.
Well, then forgive me. Keep
no
going.
worries. On this item here, I feel we have, I think, some real lack of clarity. And I asked the question in my opening when I talked to staff. We don't have a time period outlined in our bylaw. It says that how long you should be able to be in a place or not be in a place, short-term rental versus using it as your own home space for sharing with, again, children that are coming home. So I'm really struggling with this one, and I'm not entirely convinced, unless I hear something else, I'm not entirely convinced that this is a clear-cut case of an abuse of our bylaw. And I have to note that the applicant here, or the person that the case has clearly been very compliant with the inspections, responded in full, and from what I can tell, and this is different from past experiences, has not misrepresented any of the facts of this case. I've been in the business license hearings in the past for short-term rentals when it's clear that there are people who are not telling you the truth, and I don't see that's the case here. So I'm definitely struggling with this one, and I'm at this point I'm not entirely convinced that this is a case of a contravention of our STR bylaw, because I don't think it's clear enough how people can use extra space in their home.
Thank you, Councillor Klassen. Councillor Meisner, you're up next.
Yeah, thanks very much, Chair. I just want to thank you for the really detailed explanation and presentation with all those details. That was very well presented, and much like Councillor Klassen, I don't have any concerns about your honesty. I feel that you've been very upfront with the information that you've shared today around how you're using your home. I think for me, the fact that this is legally a separate unit that could be rented out on the long-term rental market, as opposed to being operated as a short-term rental, does stand out. I understand why you would want to earn income from it when it's not being used, as opposed to it just sitting there empty. But I do concur with our legal counsel in terms of a decision to reinstate your license, setting a precedent to allowing people across the city to operate short-term rentals in secondary units that they don't occupy. And that is a huge risk, in my opinion, in terms of the rental market. That's really the reason why these very strict STR regulations are in place, because there's a lot of money to be made in short-term rentals, and if people are able to do that, they will. It's just the free market. So I feel that it's unfortunate that you are caught up in this situation, but unfortunately, we are in a massive housing crisis in Vancouver, and we need to do everything we can to protect every available possible rental unit. And to me, this is a possible rental unit for somebody on a full-time basis. So in good conscience, I can't support reissuing your business license. Thank you.
Am I allowed to comment?
At this point, no, I'm sorry. Councillor Meisner, are you moving a motion to that effect? I can't, I am chairing, so I can't, and Councillor Klassen is pretty close to out of time, so. Oh, sorry.
I would like to move a motion to uphold the decision of the Chief License Inspector to suspend the business license. I'm not sure if you need that in a written form or if that's enough.
I think that is sufficient. The language was circulated. Do we have a seconder for that? Second by Councillor Klassen, and I'm going to move us to an amendment queue. No, I don't need to. It's just the main queue for a motion.
Yeah.
Okay, thank you, Councillor Meisner. Anything else? Any other comment?
Just oh, thank you very much. Just to say that I don't take any pleasure in doing that, and I do sympathize with your situation, and I hope that you can potentially find a way forward, whether that is, and I realize there's expense associated with this, maybe taking out the stove, putting in a hot plate. I'm not sure what the best way for you to proceed is, and I'm not here to give advice on that. But this is really about the bigger picture for me, and this is about preserving rental units that could be possibly inhabited on a long-term basis. And we need to do everything we can to, as councillors, in my opinion, to preserve Vancouver's rental stock. So again, I empathize with your situation, sympathize with your situation, but this for me is really about the bigger picture of housing affordability. And it's just, I have personal firsthand experience with Vancouver's rental market and the challenges that people are facing. So that's all. Thank you.
Thank you, Councillor Meisner. I'm just going to advance myself for a few closing comments as well. And again, we'll echo an appreciation for the thoroughness of the information and response that we got from you, Julie. I have been in many business license hearings where the licensee has multiple listings, where the motive is clearly profit, and where the unit, in my opinion, should unambiguously be a long-term rental, and you know, situations that are the example, the key example of these rules, and a handful of business licenses like this one where the situation is understandable and sympathetic. I mean, I will say, as a parent of a younger kid and an older kid who's away at school, I am very sympathetic to the desire to have space when that older kid, now an adult, returns and doesn't want to sleep in her bedroom that we have now turned into a home office. Also, I mean, I am very conscious of those dynamics. And as Councillor Meisner said, also the weight of what it means for one sympathetic example to shift the rules overall, and the cascading effect that can have, and that when we know that we have such a huge need for those long-term rental units. So again, I know that this is challenging. My hope would be that there's a way to come into compliance, and I know city staff have in other situations been able to meet with homeowners to go through what those different options could look like to come into compliance, whether it's removing the stove, whether it's some sort of 8-month rental, you know what, and maybe I'll say too, because it's on my mind, we have been talking with healthcare providers about, just as the licensee mentioned, the need for sort of short, medium-term rentals for people out of the city coming in for a transplant or another medical procedure. It's a topic that council will be discussing next week, actually, and so maybe there's an opportunity to work with one of those, the lung transplant folks or others, to figure out some option there that would allow compliance. And our responsibility in the context of this business license hearing really is to look at compliance with the rules that we have, which are there for good reason. It's also my position that, unfortunately, I will say, unfortunately, that the current situation is legally a separate suite, and so out of compliance with the rules as they are.
This one, thanks. Just in terms of the compliance piece, it seems to me that the DB from previously in the stove were a couple of important considerations in this one. Could you look at can you describe what a path to compliance looks like? Because as my colleagues here have pointed out, this is obviously a complex, and every one of these examples are unique, but this one has some gray area in it that I think we need to address over the long term.
I'm going to take that as a point of information.
Yeah, the
and
information
perhaps
is, what does compliance look like from the standpoint of this example? We've got a stove. I've heard about a stove. I've heard about the development permit. What are the things that make this one more likely to be, if we follow through on the decision to remove the business license? What does compliance look like from your standpoint?
Certainly. I think there's two opportunities. One is that a long-term tenants the basement, and they can make the decision of whether or not they seek a short-term rental. The other, for the homeowner themselves to be able to short-term rent, would be to go through the appropriate permitting process. While stove removal is certainly a component of that, I wouldn't be able to fully detail it without a full review of application by expert staff in that area, of removing the secondary suite, removing that approval and returning the home to one family dwelling.
Right. It's pretty clear to me then. Thank you.
Okay. Thank you, Councillor Klassen. Seeing no one else on the list, I'm going to call a verbal vote to start. All in favor?
Aye. Yeah.
Okay. None opposed. So this motion carries. This hearing is adjourned. And would again just echo an offer to make connections for follow-up with staff for those next discussions, if that is upheld. Oh, now I need a motion to adjourn. Otherwise, we're stuck in the purgatory of this hearing forever. Moved and seconded. All in favor of adjourning? Great. Okay. Thank you, everyone.